13th, 2023 at 1 p.m. And I'm Karen McGovern. I am the Interim Division Director for the Division of Professions and Occupations within the Department of Regulatory Agencies. I'll be chairing the meeting today until such time as the chair is determined. I am declaring that we do have a quorum present for our meeting. The purpose of this meeting is to act on important business related to the Colorado Natural Medicine Health Act. The board will make its decisions on agenda items today based upon written materials provided for its consideration in advance of this meeting. The public is welcome to listen in and observe the workings of the board. This is not a stakeholder engagement forum, and the public should not address the board unless requested to do so by the board. Attendees will be muted to ensure the board is able to efficiently conduct its business as is set forth on the agenda. If the board moves into executive session, the public will be notified and the board will convene privately. After the executive session, the board will return to this open session for discussion and vote, if necessary, on agenda items discussed in the executive session. Thank you for attending today's meeting and for your interest in these important matters. I would like to turn the floor over to Sam Barami for introduction and DORA overview.
Thank you, Karen. Can you guys all hear me? So thank you all for joining us today, and thank you for your willingness to serve the state of Colorado. I'm Sam Barami, the Senior Advisor on Natural Medicine Services and the Program Director. I'd like to introduce you to some of my colleagues on the call right now. We have Sarah Werner, Director of External Affairs, Kathy Duran, the Program Manager, and I'd like to hand it over to our Assistant Attorney Generals, Ashley Moeller.
Thanks, Sam. Good afternoon. I'm Ashley Moeller. I'm the first Assistant Attorney General at the Colorado Attorney General's Office. I and my team will support your work on this advisory board. I have one of my team members on the call with us now, Brian Urankar. He is an Assistant AG at the Attorney General's Office as well.
All right, Karen. All right, and now we will move into our slide presentation. All right, Natural Medicine Advisory Board. Next slide. So DORA's mission and vision. The Department of Regulatory Agencies, DORA, is dedicated to preserving the integrity of the marketplace and is committed to promoting a fair and competitive business environment in Colorado. Consumer protection is our mission. DORA by the numbers. So 668 full-time employees, a budget of $120 million, more than 40 boards, commissions, and advisory committees, 50 plus regulatory programs, over 1 million individual licenses issued, over 100,000 regulated businesses and institutions. So we have DORA's organizational chart. Do a brief overview. We'll touch back on it later on. So we have the EDO, the Executive Director's Office, the Colorado Civil Rights Division, the Division of Banking, Division of Conservation, Division of Financial Services, Division of Insurance, Office of the Utility Consumer Advocate, Division of Professions and Occupations, where this program is housed, and Public Utilities Commission, Division of Real Estate, and Division of Securities. So what DORA regulates? It's quite broad. We have financial services from accounting all the way to state chartered credit unions, real estate, buildings and repair, appraisers, architects, electricians, engineers, real estate brokers. We have insurance, insurance agents, the brokers, insurance companies. And in beauty, we have barbers, estheticians, cosmetologists, hairstylists, nail technicians. And then in healthcare and wellness, quite broad, we have acupuncturists, addiction counselors, chiropractors, dentists, physicians, nurses, pharmacists, and in transportation and utilities and other. We have quite a broad program, many programs here. Next slide. So about rulemaking, this will be a brief overview. So what is regulation? A regulation is a rule created by a state agency that has an impact on the regulated entity and on the public. The regulation is the state agency's action in implementing, interpreting, applying, or enforcing a statute enacted by the legislature and signed into law by the governor. Next slide. What is rulemaking? Rulemaking is the formal process followed by state agencies to clarify, refine, and operationalize the broad policy statutes passed by the Colorado General Assembly or Congress, or to implement federal agency regulations. Next slide. So, Administrative Procedure Act, APA, sets forth the formal process followed by state agencies to clarify, refine, and operationalize the statutes passed by the Colorado General Assembly. Rulemaking agencies are subject to the APA unless they are explicitly exempt. All agencies are required to file their rules with the Colorado Secretary of State, SOS, for publication. Colorado Code of Regulations, CCR, Office of the Secretary of State is required to compile and publish the administrative rules of Colorado's executive agencies in the Code of Colorado Regulation. Colorado Register, notices of rulemaking, proposed rules, new and amended rules, and publishes Attorney General rules. Opinions are published twice monthly. Next slide, please. So, the core components of rulemaking. Notice of proposed rulemaking. When an agency wants to promulgate a new rule or an amendment, they must file a notice of proposed rulemaking with the SOS to be published in the Colorado Register. The agency must also notify any individual who has told the agency that they want to be notified. Comment period on the proposed rule. Once filed, public is invited to offer comments. The agency must accept and consider comments before they can adopt or amend any regulation that is not explicitly exempt from APA. Hearing on proposed rule. At the hearing, the agency accepts written and oral testimony. Once the hearing ends, the public is no longer able to offer comments unless the agency alters the rule in a way that requires the process to start. Final adoption of rule. Agency has 180 days to file adopted rules with SOS, Secretary of State, for publication in Colorado Register. This goes into effect 20 days after publication or such a later date stated in the rule. Next slide, please. So, rulemaking process. This is a brief overview. Did we skip a slide? Nope. Okay. So, brief overview. The rulemaking hearing announced, the notice published, the rulemaking, the adoption, the Attorney General's review, and the rules published, adopted rules filed, and rules become effective. Next slide. Stakeholder meetings and public comment. So, stakeholder meetings and public comment help draft agency rules by attending an agency stakeholder meetings, which are held prior to the agency's filing of the notice of proposed rulemaking with the Secretary of State. You can find each agency's rules, review, schedule, contact information, and annual departmental regulatory agenda on their website. During the agency rulemaking hearings, we encourage the public to give input on a specific rule. Next slide, please. So, notice of rulemaking hearings from rulemaking agency. By contacting the rulemaking agency directly and asking to be added to their rulemaking notification list, you'll be emailed with any agency temporary or emergency rulemaking from the Secretary of State. By signing up through the Secretary of State site, you'll receive email notifications of rulemaking, permanent rules, or emergency rules that have been published by the Secretary of State in the Colorado Register. The email is also linked to associated Attorney General opinions about the rules. And from DORA. By signing up through the DORA site, you'll receive email notifications of permanent rules that are being proposed, according to specific subject areas. These notifications also include rulemaking hearing information, details about what changes are being proposed and why. These notifications also provide you with easy access to request a cost-benefit analysis of any new or amended rule. Next slide, please. Rulemaking agencies. The General Assembly delegates rulemaking authority to specified executive agencies authorized by the Administrative Procedure Act, APA, 24-4-102 of the Colorado Revised Statutes. These are the principal agencies. You can see the Department of Ag, Local Affairs, Department of Law, Military and Veterans Affairs, Higher Education, Department of Personnel, Early Childhood, Department of Corrections, Department of Education, Department of Public Safety, Department of Revenue, Department of State, Department of Transportation, Department of the Treasury, Department of the Public Health and Environment, Department of Human Services, Department of Labor and Employment, Department of Healthcare Policy and Financing, and Department of Regulatory Agencies, DORA. Next slide, please. I think we'll go on to the next section. Let's see. All right. Karen, pass it back to you.
Okay, now that we have finished a little bit of our administrative items, I wanted to move back and call the roll because now we have everybody online. So let me start with Katina Banks. Please answer present if you are here.
Present.
Wendy Buxton Andrade.
Present.
Sophia Chavez.
Present.
Bradley Connor.
Present.
William Dunn.
Present.
Clarissa Pincola Estes.
Present.
Joshua Goodwin.
Present.
Tina Gonzalez. Alyssa Hannum.
Present.
David Lucero. Lundy.
Present.
Suzanne Sicily.
Present.
Skippy Upton Messero.
Present.
Billy Wynn.
Present.
Ricardo Baca. Okay, great. I also wanted to just go through a couple of housekeeping items, making sure that we can hear each other, making sure that when you're not speaking, you're on mute. Sam and I are in the same room, so we're going to do our best to mute ourselves when we're not speaking so we don't create feedback. Making sure that you have your phones turned to vibrate or silent, and making sure that the attendees understand that you've been automatically placed on mute upon sign-in, because this is a meeting, a board meeting, a working board meeting, we like to call it. And so you are here to observe the workings of the board. I am going to turn it back to Sam. I think I'm looking here at the agenda. Just making sure, want to turn it back to Sam for his program director report.
So, since this is our first meeting, I don't have a full report out. Moving forward at our full board meeting, monthly board meetings, I will have a readout of recommendations submitted to subcommittees and any agenda items that pertain to the board or any of the subcommittees. Back to you, Karen.
Great. So now we are going to start on new business agenda item number 3, state law training. This is what we like to call in the Division of Professions and Occupations, our annual board member ethics training. Next slide, please. So the purpose of annual training for board members will be discussed in this presentation, as well as the executive branch, its boards and commissions. We will talk about the missions and goals, board duties, and staff member duties as it relates to boards, commissions, advisory boards, task force. We'll talk about board member responsibilities, and then we will cover the topics of open meetings and open records law, identifying and managing conflicts of interest, common pitfalls that may create the appearance of impropriety, and then we'll just go over some takeaways. Next slide. So the purpose of ethics training for board members, the overarching purpose is to inspire public trust and confidence in the integrity of state government. When you think about how we work, I think it's important to understand that the people of Colorado view board membership as a trust, existing only by virtue of the public's confidence in the honesty and integrity of the government. And so the confidence can't exist if the public believes that boards function to further their members' personal interests. The other reason that we do this training on an annual basis is to fulfill the requirements of House Bill 181198. So that year, the legislature codified what we at DORA had already been doing in making sure that board members receive the annual training. I put a picture of the act. I know it's blurry, but I think if you were interested, you could either look in the Colorado Revised Statutes at 24.3.7.102, or you could look at the House bill to see how the legislature set out what topics needed, specifically to be covered. Next slide. Can you hit it again? There you go. So when you think about the executive branch, I like to start our training kind of going back a little bit to civics, because I think it's important to understand where we fit in the government to understand our role. So there's three branches of government: the legislature, the executive branch, and the judicial branch. In the legislative branch, their job is to make the law. And in the judicial branch, their job is to clarify the law. The executive branch, our duty is to enforce the law. And we are led by the governor. The governor, leads the state with the help of his cabinet, and the cabinet is made up of the executive directors of all of the state agencies. There are some that are pretty familiar to everyone, especially since the pandemic. People are acutely aware of the health department, the Department of Corrections, the Department of Wildlife, and then you have the Department of Regulatory Agencies. We stand out within that group of state agencies because our sole purpose at the Department of Regulatory Agencies is to house smaller regulatory agencies. So that's why you'll often hear DORA referred to as an umbrella agency, because all the different regulatory agencies are under the big umbrella. Sam went through DORA and explained how it's divided up into divisions. I sit within the Division of Professions and Occupations, and that is where this board will sit. The Division of Professions and Occupations is the biggest division within DORA. If you think about DORA as a whole, it regulates roughly 900,000 licensees, give or take. The Division of Professions and Occupations regulates 500,000 of those. So we're the biggest in scope. We're also the biggest in number of employees. The scope, our scope is that we regulate 53 professions, and we do that through the administration of 22 boards, 17 director model agencies, a task force, a commission, and now an advisory board. We are what is known as the little umbrella under the big umbrella of DORA, because again, every single one of those boards, commissions, advisory boards, those are all separate agencies, right? And you, as part of an advisory board, make up that agency for the Natural Medicine Health Act. Next slide. Okay, you can go to the next one because Sam covered this in his Okay, so this, when we think about the division of professions and occupations, I listed out all our different agencies, so you could just see sort of how they sit. Right in the middle, I have us, the Natural Medicine Advisory Board. Each board, each name here, each profession is defined through its Practice Act. And I just mentioned you guys have the Natural Medicine Health Act, and that will be referred to as the Practice Act. The duties of the boards are set forth in the Practice Act, right? And some boards are responsible to grant or deny license applications, to impose public discipline, including revoking or suspending a license, the issuance of declaratory or other orders such as cease and desist. And then, as is really important for this board, especially right now, is to clarify the act as necessary through rulemaking. And that's really what we will be focused on, particularly at the beginning of our work together. Next slide. So the mission of DORA and DPO is consumer protection. And that's really, you find that in each one of the agencies that sits within the department and the division. Our mission is always weaved into our goals. We have several goals that are set out annually, and you can find those on the DORA website. Right now, we look at balanced regulation to ensure effective enforcement to protect consumers while reducing undue burden. That's been a major goal for us for the last several years, is cutting red tape to get people into the profession. Our next one is accessibility through education and outreach, and then modernized and bold operational improvements to better serve stakeholders. And believe it or not, having these meetings virtually where we can have 125 people online is one of those improvements. And it's actually one of, I guess, what you can say a silver lining from the pandemic was teaching us how to do things remotely. So we can really have people from across the state attending meetings and participating. Next slide. So you as board members will interact with staff, and understanding that, we're a team. And I always like to start with that, like we're all rowing in the same direction. And so you can expect staff to provide administrative support for you as board members. You can expect your staff to handle the day-to-day functions of the advisory board, to make sure that the board meetings and rulemaking support is provided to you, to make sure that stakeholder engagement is done. They will identify and secure sufficient data for the board to make decisions. They'll ensure the appropriate involvement of members in the review of key communications and in policymaking activities. They'll coordinate with other boards or commissions if responsibilities and interests may overlap. And then they will actually carry out any duty that you may decide as a board to delegate to them. Okay. So now I want to move into board member responsibilities. I always like to tell people it's an honor to be selected to sit on a board within the executive branch. 98% of our board members are selected by the governor, and all of you were selected by the governor with an extra step of being confirmed by the Senate. So that it really is quite an honor considering the number of people that applied and really the high visibility of this board. But with that honor comes a lot of responsibility, because as a board member, you have that duty to the public that we discussed early on. And so board members are responsible to maintain the integrity of professional regulation. And what that means is that you really need to maintain a working knowledge of your laws, rules, policies, and procedures. You'll need to comply with conflicts of interest requirements, open meetings law, and public record requirements, and we're going to go over those in more detail. And you're going to need to adhere to division communication guidelines, and we're also going to talk about those. Board members are responsible to remember that they represent the governor and the executive branch, and to do so in a professional manner. Board members need to present to meetings in business attire and need to act in a professional, courteous manner. We're all here as board members. We will all have different opinions, and we just need to remember to be respectful and listen. And that really is part of representing the executive branch. Also, you need to prepare for and attend scheduled board meetings. It's really important. Each of you were selected because of your unique perspective. And so the best decisions of this board are going to be made when every perspective is represented. So it's really important that you're here. Board members are responsible to act within the limitations of the executive branch. And this is why I went over a little bit where we sit in the government, because our job is to enforce the law. And so as board members, we can't be engaging in legislative matters related to the law that we're charged with enforcing, because that creates the appearance of impropriety with the public. And so that's why we ask you not to engage in legislation regarding the Natural Medicine Health Act. And then you're responsible to observe the highest standard of ethical conduct. And this goes back, what I talked about earlier. It's making sure that you maintain the public's trust in government. And to do that, we ask that you adhere to the board member code of ethics. We provided each of you with that, and you reviewed and signed it. That is really sort of a one-stop shop that has all of the professional ethical responsibilities of a board member in one document, so that you can look at that and quickly ascertain what you need to do. Again, making sure that we comply with conflicts of interest requirements, open meetings and public record requirements, and then keeping confidential matters confidential. And we'll talk about that in more detail as well. So let's start with the communication guidelines. I think the important piece to remember is the board only speaks as a unit. And so what that means is there is not one member, not a chair, not a subcommittee chair. There's not one member of the board that is authorized to speak on behalf of the board, unless in an open meeting like we're in today, the board delegates one person to speak on its behalf for a specified purpose. So an example of that would be for some of our regulatory boards, when they are attempting to discipline a licensee, they will need to go to mediation. A board member needs to attend the mediation with the Attorney General. And so the board will say, we designate or delegate to Joe Smith to speak on our behalf at the mediation for respondent X. And that happens in open session, and the board votes on it. And then that person is allowed to speak on behalf of the board in that very prescribed instance. Otherwise, it doesn't happen. And you might say, well, how does the board speak as a unit? Well, the board speaks as a unit in meetings through their working and collaboration. They speak in the rules that will be promulgated based on your work. They speak through declaratory orders if a request for a declaratory order were to come in. That's how boards speak as a unit. So when you keep that premise in mind, then the rest of these become very easy. So media requests. If the media reaches out to you and is requesting information or requesting an interview, you need to forward that to Sam, who will make sure that the public information officer is looped in, and they will speak with the media. If someone asks you to do a presentation, same protocol. You talk to Sam. Now the board may say, we would like you, board member Joe Brown, to do this presentation, so we're going to delegate it to you. Okay. Absent that, you need to turn that over to Sam, and he will make sure that someone from the staff can get that accomplished. people will ask your opinion. They will ask your professional opinion. They will say, you are on the Natural Medicine Advisory Board. What is your opinion about X? You need to make sure that if you're going to give a professional opinion, that you preface it with, I do not speak for the board. So Karen McGovern, I can have a professional opinion about being a lawyer, and I can have a professional opinion about the law, but I can't represent the agency. I can't say Dora thinks this or the division thinks that. I can say, personally, I think this, but I don't speak for the Division of Professions and Occupations. And that's what you will do as board members. I am not saying at all that you can't offer your opinions. You just need to make sure that the person you are giving your opinion to understands you do not represent the board. Stakeholder contact. You will have a lot of stakeholders reach out to you. All of our boards have that. We ask that you not engage because you may be creating a conflict of interest for yourself. And when it comes time to discuss the matter at the meeting, you may be forced to recuse from the matter because you've created a conflict. That's the only reason. We want to make sure that as many people as possible can vote on every single item, because like I said, we have so many different perspectives, and the best decisions are going to be made when all of those perspectives are represented. Records requests. If you receive an open records request, you will send that to Sam, and our team will process that open records request. And we're going to talk a little bit more about that later. And then licensee or applicant contact. I think that's in the same bucket as stakeholder contact. Once licenses start being issued, you will be surprised at the number of people who will reach out and say, hey, my application's in the hopper. What can you help me? What can you do? Or I have to fill this out. Should I answer this question, yes or no? Again, once you engage with that applicant, then when their application comes up for the vote, you'll have to recuse because you have information outside of the board meeting. So that's why we say, I can't help you, but Sam can. And then you give them Sam's number. Next slide. We talked a little bit about board member responsibilities were to keep confidential information confidential. The most important thing, there are a couple, I have them bulleted over here. The first is, do not discuss board matters outside of board meetings. So when you start talking to people about what happened at a board meeting, you may forget what part was talked about in open session versus what part was talked about in executive session, or which information might be confidential by law. And so it's very easy to just forget what part of the meeting you were in when you start telling something. And we don't want you to violate open meetings law or executive session or inadvertently waive attorney-client privilege. So what we say is, just don't talk to people about what happened in the meeting. These meetings are open for the public. The public can sign in and they can listen to the entire meeting. If you know something is confidential by law, and what I will tell you, and it doesn't really apply this early in our work, but medical records are confidential. Everybody recognizes that you can't talk about people's health conditions in a public meeting, right? So if you were to have something like that, when we start issuing licenses, you just want to be really careful not to talk about that in open session. And then the last thing is using optimal computer privacy practices to secure your packets. We have the Governor's Office of Information Technology who helps us oversee that, but just making sure that hacking has just become so rampant that we always want to make sure our board members understand, I personally love to work at Starbucks, but I need to take my phone and connect to a hotspot so it is a secure connection. Starbucks has a great Wi-Fi, but it's not secure. Making sure that when you're doing state business, you're only doing it from a secure internet connection. I always say, and I am very good about this in practice, I password protect my laptop and I password protect confidential documents. So I double password protect things so that if I lost my computer, if I left it somewhere, if someone took it out of my car, I mean, we've seen all of these things happen. Last year, we had one of our program directors pulled up into a hotel valet, and he was talking to the valet, and someone drove by on a Lime scooter and stole his computer bag out of his car while he was standing there. And his work laptop was in there. So, you know, he felt very secure because the laptop was secured, the documents were secured. My point is just that it happens even to people who are super careful. Making sure that you only keep the current packet stored on your device. So once you finish a board meeting, getting rid of any confidential information. I think now that we're really working through the rulemaking, it's not likely that we have confidential information. So it's not as serious now as when we start looking at licenses. And again, if we are concerned about privacy and hacking, making sure that we delete the packet and empty the trash. What we are, I think, primarily concerned about is personal identifying information, because that is what hackers want. So to the extent we have that in packets, we will let you know and make sure that you delete that from your device. The reason I say that is if you lose your device, if somebody does drive by on the Lime scooter and steal your laptop, if you have one packet on your device, that's a breach. But if you have like packets from the last 3 years on there, that's a whole different level. Okay, so now we're going to talk about open meetings law and open records law. So bear with me. It's tedious and it's long, but it's really important. So when you think about democracy and sort of how we got to where we are as a country, you recognize that that democracy depends on informed and active participation of citizens of all levels of government. And so in order to encourage this participation, Colorado enacted its Sunshine Law. And through its Sunshine Law, we have open meetings and open records law. Basically, the policy of the state of Colorado is that the formation of public policy is public business and therefore may not be conducted in secret. And the open meetings law is broadly interpreted to that end. It's to further the legislative intent that citizens are given a greater opportunity to become fully informed on issues of public importance, so that meaningful participation in the decision-making process may be achieved. And I just read that, came from a Supreme Court case. It's really informative when you think about why do we have open meetings law? How does that apply to you? Basically, this board falls under the definition of a state public body as an advisory, policymaking, rulemaking, decision-making, or formally constituted body of any state agency. What that means is open meetings law pertains to us. Open meetings law says that all meetings need to be held in public. All meetings of a local governing body, which is us, have to be held in public. Now, there are exceptions because they're depending on the board in our division. We have some that are open boards, such as yourselves, where everything is conducted in open with the exception of executive session. We have some boards, however, that their enabling act specifically says that their work on disciplinary matters is not subject to open meetings law. And so they are allowed to hold those meetings in a closed session where the public is not invited. Absent that specific language, boards are open to the public. What is a board meeting? And that seems really silly, right? You know it when you see it. This is a board meeting, right? A board meeting is defined that 2 or more members of a board discussing board business is a board meeting. So that means if you are on your morning jog and you stop off at Dazbog's Coffee and you run into a fellow board member, and while you're waiting in line, you start talking about rulemaking, you have just had a board meeting. I tell you that because what is incredibly important for you to remember as a board member is that you can only talk to other board members about board business in a formal meeting such as this. Meetings have to be noticed to the public. And in order to do that, we need to tell the public where you're meeting, when you're meeting, who's attending the meeting, and what the meeting is about. So you use my Dazbog example, you've just violated open meetings law because two or more board members discussed board business and you didn't tell the public where you were meeting, when you were meeting, who was going to be there, and what you were discussing. That's an open meetings law violation. It's as simple as that. When we talk about board members discussing board business, doesn't have to be in person. It could be on the telephone. It could be over email. It could be over text, over chat. It doesn't matter. The definition of this discussion is very broad to include writing as well. And so something we are very staunch about is making sure that we don't talk about board business with board members outside of the meeting. So here's a good example, and I want to use today's agenda. We noticed the meeting for 1 o'clock. When we all got on early, when we were trying to make sure we had our connections, we didn't talk about board business. And if you recall, we're very clear, like, do not talk about board business. That's because we told the public the meeting would start at 1. And so we can't talk about board business till we gavel in, call the meeting to order. We can talk about board business as long as we are in session. If we take a break, we cannot talk about board business during the break. It's much easier in the virtual world, right? Sometimes if we have meetings in person, sometimes it's just easy to chat while you're waiting to get a coffee or a water or something. But you just have to remember. And then as soon as we gavel the meeting out, you can't talk about board business again until you reconvene in a meeting that was noticed to the public. I think that the one exception, and we talked about this, I touched on it briefly, is executive session. So executive session, the board considers information that is confidential by law, is guidance from the attorney based on, it's called litigation guidance. So if the board were being sued or if the board were prosecuting a disciplinary matter, you're allowed to get guidance from your lawyer there, or any other attorney-client privileged conversation. So just because you're an open board doesn't mean you don't retain the right to have a private conversation with your attorney. You have to remember that when you leave executive session, you can't talk about anything that was talked about in executive session publicly because you could waive your attorney-client privilege, right? So what happens in executive session stays in executive session. The other important piece of executive session is that you can't make decisions in there. You're only in there to be getting advice or talking about, say, a medical record. But once you have received the advice, then you must come back into open session and have your discussion and vote on the matter. That's something that the Attorney General will be helpful in assuring that you do that correctly. In Colorado, we're very lucky. We have great attorney generals and we have a great relationship with our attorney generals, and they are present at every meeting to make sure that the board understands the laws and that they're abiding by the requirements of the Practice Act or the Natural Medicine Health Act, but also open meetings law, open records law, conflicts of interest. I think it's important, and we talked about not adopting any rules. I think it's important to just, again, make sure that you understand that the requirement for these meetings is that we provide timely notice to the public about the meeting. And so what we do is we will put the agenda up on the board website on the calendar. So you can look, you can see when the next meeting is, you can click on it, and you can see the agenda. We will post that at the Natural Medicine Health Act homepage calendar. I'm going to ask one of my colleagues here to type that into the chat so that you all have that web address so that you know where to look for the meeting agendas. The last sort of requirement for open meetings law is that minutes of the meeting are taken, that they're promptly recorded and available for public inspection. How that works here is that we will post the minutes to that same website at the meeting, once the board has a chance to adopt the minutes at its next meeting. So the minutes for today will be presented to you at your next full board meeting, and you will look through them, make sure they're correct, and then you'll vote to adopt them. At that time, we will post them up on the website so the public can look at the minutes. So all that's a lot, and I think we talked about it. I'm going to say it one more time because it's that important, is we just need to make sure that we're not talking to each other about board business except between the gavels, gavel in and gavel out. I think the other piece we need to talk about is open records law. And open records, I like to say, is like the cousin of open meetings law, right? It's the same thing as open meetings, only it is about the records. So a public record includes writings that are made, maintained, or kept by the state for use in the exercise of functions required or authorized by law. I think the important thing to remember is this includes emails that you may send in your capacity as a board member or that you may receive in your capacity as a board member. That is why you were all issued state email accounts, because you should be doing all your board business from that account. We ask that you not delete any of the emails from that account, because if we get an open records request, we may have to ask you to produce those depending on what the request is. I think it's interesting when you think about open records requests is to think that the presumption is that all records are open for public inspection, right? That is the presumption. That's where we start. If we get an open records request, we take all the records that pertain to the request. So if the request says, I want all board records from October 1st to November 30th, we get every record that has been made or kept, maintained during that period, and we put them in a stack, right? And then we go through them to see which records are actually public records. And by that, I mean, just like all law, there's always an exception, right? So the presumption is that they're all public, and then you open Colorado Open Records Act and you look at the 2 pages of exemptions and exceptions. So what is exempt? We wouldn't have time to go through all of them, but I think there are some that are pretty good examples. Medical records, exam scores, trade secrets, attorney-client privilege communication. So when we get that stack of records that are presumptively open, we go through with the assistance of the Attorney General and we take out information that is not public because the law says it's not public. And then we produce the records. So that's really how that process works. I think it's important to understand that, and sometimes people don't seem to understand when you're sending emails as in your capacity as a board member, those are all open record. They're all subject to review by the public. And so it's important that you carry yourself with the decorum of someone who represents the executive branch. And also important that as a member, you are retaining all of those emails. So key points, we've gone through them. I'm not going to read this to you, but you can see I pulled out, these are the things that are really important. A question I get asked a lot is, well, what's the penalty? Like, what happens if we violate? There's a lot of potential consequence. The biggest, the one I think that bothers me the most is just the negativity it creates within the community, right? Again, what we're trying to do is maintain people's trust in government. And every time that we hold a meeting that's not noticed, or we, don't have records to turn over, it just erodes at that trust. And so really just working hard to not do that. There's also some legal consequences. There can be an invalidation of a decision or action of the board that was made in violation of open meetings law. If you're found to have engaged in a violation of open meeting or open records law, and it's determined that it's willful misconduct rather than just an accident, you could be removed from the board, or you could lose qualified immunity that attaches to board members, which says that as long as you're acting in good faith, you're represented by the Attorney General if you are sued civilly for your actions as a board member. And then the board might have to pay attorney's fees if you were sued for a violation and it was found that the violation occurred, then the board will have to pay the attorney fees for the other side. That's very likely penalty. Okay, next slide. So conflicts of interest. I'm going to talk to you about conflicts of interest. And I know that Ashley will be available in executive session, so you can ask her questions about that. There'll probably be a lot of questions. There's usually questions that board members have, like, well, if I do this, is this a conflict? Those Ashley can address with you in executive session, because that would be attorney-client advice. So essentially, a conflict of interest arises when a board member's ability to make a fair and honest judgment in the public interest either is or could be perceived to be impacted by a personal or financial interest. When you think about that, personal or financial interest is pretty broad. We don't just have a financial responsibility. There's also the personal responsibility. I think the most important thing that I can impress upon board members is that your job as a board member is to always act in the interest of the people of the state of Colorado, right? It's not your personal interest. It's not your business interests. We have a lot of people who are interested in the business component of natural medicine. And you would have to disclose that interest and recuse, because you can't have two loyalties. You can't have a loyalty to your own business, but you also have a loyalty to the people of the state of Colorado. At a minimum, that's a perceived conflict of interest. Even if you were 100% sure that you could be fair, and I would assume most of you can, that's not what the public sees. I always like to use this example because I think people understand it. In a lot of our healthcare boards, some of our professional members work for the University of Colorado. And the University of Colorado is a huge medical school, residency program. They've got a lot going on. And so they can be vested in some of the rules that are promulgated by, let's say, the medical board. If the university is asking the medical board to promulgate a rule, we can't have physicians on the medical board who are employed by the university voting on that rule or discussing that rule. Because when the public looks at that, they say, the university is in charge of your career. They're in charge of your income, your tenure, your professional reputation. How can we be sure that you're not voting for this rule because you're worried about your own self, right? I would say that's not true. That these board members, they are very good at separating, but it doesn't matter because the public looks at that and they see it as a betrayal. And so that's why it's really important to say, if you have a personal or financial interest in something, you need to recognize it as a real or perceived conflict of interest. So if you have it, how do you manage it? So when either you recognize the conflict or your program director recognizes the conflict or your attorney general recognizes that there's either an actual or perceived conflict of interest, the board member will be required to recuse from all discussions and voting on that issue. It's always important, if you have to recuse, to say, I'm recusing from this matter. That's all you say. You don't tell why, you don't have to explain it, because you don't want to taint the rest of the members who are left in the group to vote by stating what your interest is. So one example is, let's say we're going to go back to the medical board, there's a disciplinary matter and the board member's wife is the person who is being disciplined. And if he stands up and says, I have to recuse, this is my wife, then there are people on the board who will be like, ooh, we don't want to ding his wife because he's our friend, right? So he's just inadvertently tainted the rest of the people who are left to vote. So it's just important to just say, hey, I'm going to recuse from this. And then the people left to vote don't know. I always say, if you have a question, if you're not sure, you talk about it with your program director and your AG, because they're not voting members. And so you can tell them the whole story and they can help you figure out whether or not it's a conflict. If there are so many people in the room that have a conflict that the board can't do business, then the Attorney General can invoke the rule of necessity. I'm not going to go through that because if it happens, the AG is going to walk you through it when that happens. The possible sanctions for violations are exactly the same as a violation of open meetings law or open records law. It's the erosion of public trust, it's the invalidation of the board's determination, and then the potential loss of qualified immunity or even your seat on the board. Next slide. These I'm going to just leave up here for you to read them. We've pretty much talked about the first one, is making sure that you exercise your licensing, enforcement, rulemaking, and policy decisions independent of external influence. I gave some examples: gifts, financial interest, business interest. I say it's loyalty. If you have a loyalty to two things, you have a conflict. The next thing that I think is important to understand is you cannot use your position with the board to advance your private interest. So if I'm sitting on the nursing board and my mom is in the hospital, I don't get to go out to the nurse's station and say, hey, I'm a member of the nursing board, you better get in there and treat my mom well. You don't get to do that. And I think for this board, it's going to be particularly important to remember that, because what you absolutely don't want to do is be out and using your position on this board to I'm trying to think of a good word, to enhance your professional money-making ability. And then the last one is don't do not attempt to influence treatment, favorable or otherwise, for any person or entity from the state, the department, the division, or any board or program. This is classic, is that you don't, and you see it in the news all the time, people who are members of the government, if they get stopped by a police officer for a DUI, the first thing they say is, oh, well, I'm a board member, or, oh, I'm a this. And you just don't get to do that. Those are the three basic tenets. Make sure that when you are discussing and voting a matter, you don't have an external influence. Don't use your position to advance your personal interest, and don't try to attempt or influence treatment, favorable or otherwise, for you or for any other person. You don't get to call and the DMV and say, my son needs to get his driver's license test today because I sit on the Natural Medicine Advisory Board. I don't think it would work, but that's just an example. All right, next slide. So we're coming towards the end. When you're talking about the appearance of impropriety, these things, while they're not necessarily a conflict of interest, they create that perception. And one is if you're acting as an expert witness for the profession you're charged with regulating. So if someone calls you to a civil case and asks you to testify as an expert on natural medicine, that can create a conflict of interest for you. It's not in and of itself a conflict, but it's likely to cause one. So we ask that you not do that. Holding a leadership position with a professional association or society, it's the same thing. If I'm on the Physical Therapy Society as a physical therapist, my job is to promote physical therapists, is to promote the profession. So I do that on Tuesday. And then on Thursday, I come in and I'm supposed to look out for consumers as a member of the Physical Therapy Board. The public doesn't believe you can do that. They don't believe that you can be for one side one day and be for another side the next. So we ask that if you want to be in a leadership position, you wait until you finish your board service. Conducting individual research on a case. This will become important as you move into the licensing aspect. You will be provided information with a complaint or an application. We ask that you not go out on Google and try to find additional information. One, because it's not verified. Who even knows if it's true? But second, we can't have 15 members at the table all having different information. You need to vote on the same information. So if you need additional information, we have an Office of Investigations that can get that information, put it in a verified report for everybody to look at. We talked about speaking on behalf of the board without proper delegation, and so I'm not going to belabor that. And then arrests or failure to adhere to professional standards. If that happens, you need to let Sam know immediately, because again, once you make a decision as a board member, people will be looking to attack your credibility, and so it's good to get ahead of those things. Next slide. Here are the training takeaways. 2 or more members discussing board matters constitutes a meeting, subject to open meetings law. Don't do it. Don't discuss matters that are before the board or which may come before the board with anyone outside of the board. If you're aware of an issue before it is presented to the board, you probably have a conflict. That really applies more to the licensing or application aspect. We just went through how you disclose your interest. You need to just say, I have to recuse. You leave the room while the discussion is taking place. We're virtual. That means you have to sign out of the Zoom call, and then Sam will text you when you can come back. And when you come back, you don't get to say what happened. Nope, you just don't talk about it. We talked a little bit that council can invoke the rule of necessity to make sure there's enough people to vote so the board can act. If in doubt, it's always best to err on the side of caution. If you think you have a conflict, some people will just recuse. Other people will sit down with the program director and AG, and that's what I think really is the best option, is to have them help you work through it. And then if you have any questions, you consult Sam or Ashley or Brian. Next slide. Okay, we talked about questions. If you have questions that you're not asking for advice, you can ask me if they're just like clarification questions, or you can hold them for Ashley in executive session if it's for legal advice.
And Karen, sorry about that. If you have legal questions, I'm happy for you for board members to raise them here. I'll take them down. We'll include them in our executive session script,
Okay.
and so it'll be clear.
Okay.
Thanks.
So yeah, if you have questions, you can ask them, and then Ashley will write them down so you can talk about them in executive session. So just unmute yourself and give it and let us know what you have.
I'll jump in. It's Sue Sisley. That was really helpful presentation. My question is about this upcoming meeting in June. There's a psychedelics conference in Denver, and I know many of us are scheduled to speak at that event, which means we'll be together. There is a chance we'll be interacting. Of course, I hope we would all abstain from talking about board matters, but just as a precaution, is it better to go ahead and make an announcement about the fact that we will be congregating there, just as a added layer of protection so people can be aware of that?
That's a great
Okay.
question, and perhaps we should address that in executive session. So I've written it down.
Thank you.
Who else? Don't be shy.
Hi, this is Elisa Hannum. Thank you for the presentation. It was very helpful. My question is about people applying for subcommittees and relationships with those people. So I think, again, for executive session.
Okay. Thank you. Who else? All right. Well, with that, I am going to pass the mic back to Sam to talk about the Natural Medicine Health Act. Actually, is it?
Ashley.
It's Ashley. I'm turning it over to Ashley.
Thanks. Hi, everyone. Thanks for your patience as we roll through what feels like a lot of slides and a lot of information. I know that this is board meeting number 1 for some of you, and it's your first time engaging in kind of a state public body, if you will. And so thank you for your patience as we kind of roll through this. I just want to give you a very, very quick overview of the Practice Act, if you will, the Natural Medicine Health Act of 2022. Next slide, please. Essentially, the purpose of the Act is to establish new compassionate and effective approach to natural medicine, and you're going to do that in a number of different ways. You will essentially be developing the regulated access program. But as you know, as you may know, there is a different and secondary component to this act. Essentially, it removes the criminal penalties for personal use for any adult over 21. So the act is intended to kind of help adopt public health and harm reduction measures along the way in that personal use pathway, if you will. The act is also intended to kind of help give some public education related to the use of natural medicine and to appropriately train first responders. Some of those individuals may already have a good base knowledge, but by decriminalizing, there's an expectation that there will be more widespread use. And as a result, if there are adverse events, it's important for our first responders to know how to carefully handle that. And then finally, your primary role in this board is to help make recommendations around regulated access to natural medicines that have shown promise in helping with well-being, life satisfaction, and overall health for adults over 21. Next slide. So I spoke a little bit about this. It does decriminalize the cultivation, possession, and personal use of natural medicine for individuals 21 plus. It directs DORA, this agency, to establish a regulated access program, and it establishes this board for the purpose of advising DORA on the substantive matters, including the implementation of the regulated access program. Next slide. So what is natural medicine? Well, that's a really good question. The statute defines it as the 5 substances: DMT, ibogaine, mescaline, that's not derived from peyote, psilocybin, and psilocin. However, and so those are decriminalized as of today under the statute. However, as it relates to the regulated access program that you will be giving recommendations on, it's only psilocybin and psilocin until at least June 1, 2026. However, if you make recommendations to include those other substances, then in fact, DORA may add one or more of them starting June 1, 2026. So what I will point out as we're talking, there will be ongoing recommendations beyond that first set that you're expected to make. Next slide. So the provision of natural medicine under this program, the regulated access portion of the Act, is fairly inclusive. So individuals will be regulated if they choose to provide natural medicine services. They'll be licensed as facilitators. Then there are certain entities that will be known and licensed as healing centers, and those organizations will cultivate, manufacture, supply, or sell natural medicines. Those are certainly could consist of very different entities. If the entity hosts an administration session, they must also have a license as a healing center. The statute requires that natural medicine services include 3 different sessions: a preparation session, an administrative session, and an integration session, which would be completed by a facilitator. Next slide. So what's your role in this? Within the regulated access program, this board will make annual recommendations regarding a number of different aspects of the program, including public health approaches and education requirements, research targeted toward the efficacy and regulation of the natural medicines. You will make recommendations regarding training programs, education requirements, and experiential requirements toward the goal of giving requirements for licensure for facilitators. The Act also requires you to make recommendations regarding affordable, equitable, ethical, and culturally responsible access. Other regulatory considerations that might apply to the 3 natural medicines that are not currently within the definition of the regulated access program. The addition of those substances and whether they should be included. You will make recommendations on the rules for the program to adopt. And you'll also have some input around data collection, reporting, and publication of information related to the implementation of this program. Next slide. So from a timing standpoint, the first set of recommendations are due by September 30 of this year. That is fairly close in terms of timing. So you are about to launch into a lot of work. And then by January 1, DORA is expected to adopt rules regarding facilitators and to approve training programs. Finally, September, a year from now, DORA will adopt certain rules to implement the program, and start taking licensure. Next slide. And I think this goes back to Sam.
Yeah, thank you, Ashley. All right, so we're going to get into the subcommittees and the subcommittee process as outlined in your bylaws, but we're going to go over that full process. Next slide, please. All right, the subcommittee process. So today the board will adopt the subcommittees. The board members review the suggested subcommittees, decide to make any edits or adjustments, adopt the subcommittees. Members are assigned. Members will be allocated to subcommittees at the first board meeting based on expertise and interest. Subcommittee meetings will be established on a regular cadence in accordance with board member availability at the first board meeting. So, subcommittee meets. The subcommittee meetings will occur at least once a month, but as we know that the statute that we have a recommendation deadline of September 30th, 2023, we are suggesting that preferably twice a month between April and September 2023 for all of the subcommittee meetings. More frequent meetings may be held based on necessity. Subcommittee drafts policy. Once they meet, the policy is drafted at the bi-weekly subcommittee meetings and submitted to the full board for review. The full board will meet monthly to review the proposed policy recommendations. Next slide, please. All right. Subcommittee establishment. The board, by vote, may establish and appoint additional special subcommittees as it deems appropriate in carrying out its purpose and functions. The resolution establishing such board subcommittees shall state the purpose, composition, guidelines, timeline, authority of each board committee. No board subcommittee shall have the authority to amend, alter, or repeal these bylaws, elect, appoint, or remove any member of any other board subcommittee or any board member elected, board officer, or employee of DORA. Authorize the sale, lease, or exchange of any substantial property or assets of the state of Colorado, DORA, the program, or the board. Amend, alter, or repeal any resolution of the board. The board may delegate to the chair the responsibility of appointing board subcommittees. The designation and appointment of any such board subcommittee by the board or the chair, and the delegation thereto of authority shall not operate to relieve the board or any individual board members of any responsibility imposed on it or them by law. Next slide, please. So subcommittee rules, part 1, invited members of the public or the stakeholder community who participate in subcommittee meetings should voluntarily disclose conflicts of interest to the department and the board. The board may adopt procedures to ensure integrity and quality control of experts or consultants invited and literature provided to subcommittees and or the board. The board chair, in consultation with DORA, may request changes to subcommittee agendas to meet specific timelines. Board members, expert or consultants, and non-voting participants of subcommittees are expected to adhere to the highest standards of ethical conduct. Meetings outside of a regular advisory board meeting must be authorized by these bylaws and be in compliance with Colorado's open meeting laws and Open Records Act. Next slide, please. Am I on the wrong? Same one. Okay. So subcommittees. These are suggested subcommittees. We have public health and health equity. The scope of work is broad, and some of these will overlap. And at the end of my presentation, we'll move into a session where we will open up for comment, edits, suggestions on the subcommittees. We're keeping them to 6 based off of time commitments and the meeting cadence. But I'll go back into public health and health equity. Focus would be healthcare, insurance, and policy disparities in access to healthcare services among different communities, public health, drug policy and harm reduction, veterans issues, indigenous and religious use, its own subcommittee, traditional indigenous use of natural medicines, and religious use of natural medicines, focused on defining traditional indigenous use of natural medicines and defining religious use of natural medicines. Harm reduction, public safety, again, public health, harm reduction, drug policy, past criminal justice reform, safety requirements for licensed facilitator operators, operations, public standards and awareness, educational standards, products research and data. So this is natural medicine research and data, the reporting standards for licensed facilitators, as we discussed about expanding data program, mycology and natural medicine cultivation, medical and behavioral health providers, testing and dosage standards, emergency response, safety and ethics, emergency medical services and services provided by first responders, medical and behavioral health providers and practices, veterans issues, and then qualifications, licensing, and training all in one. So natural medicine therapy practices, permitted organization criteria, medical and behavioral practices, training standards and criteria, licensing standards and criteria, and dual licensure considerations. Next slide, please. So, subcommittee composition part 1, subcommittees shall consist of 3, 5, or 7 members of the board. Board members shall be assigned to no fewer than 1 subcommittee. Subcommittee members of the board may elect a subcommittee chair to conduct subcommittee meetings and to collaborate with the director on agenda items for both subcommittee and board meetings. The subcommittee chair, if elected, shall serve a term of 1 year. A subcommittee chair shall serve no more than 2 consecutive terms. The executive director or the director may request that members of the public or stakeholder communities serve as experts or consultants in a subcommittee meeting. Any such individuals will serve as non-voting participants or members of the subcommittee. The executive director or the designee or the director may participate in a subcommittee meeting as a non-voting participant. Next slide, please. Sorry. So non-voting participants of subcommittees serve in an advisory capacity only and do not have any decision-making authority. Non-voting participants may not participate in any voting during the subcommittee meetings, nor may they make or second any motions. Non-voting participants of subcommittees should disclose conflicts of interest to DORA, the board, and the subcommittee prior to participating in any subcommittee. The board may adopt procedures to ensure the integrity and/or the quality of literature considered by the opinions of any expert witness and other non-voting participants considered by the board or any subcommittee. Persons and entities engaged in lobbying as defined in section 24-6-301, 3.5 of Colorado Revised Statutes may not serve as non-voting participants of subcommittees. In the event that subcommittees solicit public comment, persons or entities making public comment, either in writing or verbally, should disclose their financial interests and any other ties to the natural medicine industry as part of their public comment. All subcommittee board members, non-voting participants, and those offering stakeholder or public comment are expected to participate in the furtherance of the duties and responsibilities of the board. All participants are expected to adhere to the highest standards of ethical conduct. Next slide, please. So, quorum, meetings, and executive session. Quorum and meetings. When exercising authority delegated by the board, a majority of the appointed membership of the board subcommittee shall constitute a quorum, and the act of the majority of the members present at a meeting at which quorum is present and shall be the act of the subcommittee. Minutes shall be recorded of each such meeting and submitted to the board in a timely manner. Each board subcommittee may adopt rules for its own activity, not inconsistent with these bylaws. The board's resolution establishing such subcommittees shall be open to the public, and proper notice must be given before the meeting. Executive session. From time to time, the board subcommittee may have need to enter into executive session for discussion of items that are by law to remain confidential pursuant to section 24-6-402, 3A and B of Colorado Revised Statutes and their subparts. The subcommittee may not enter into any executive session without timely notice to the public of the topic to be discussed and without conferral with the board's legal counsel to craft the notice language and motion language to protect the board's confidential interests. A 2/3 vote of the full subcommittee membership and not merely those present is required to enter into an executive session. Next slide, please. So we have our suggested subcommittee assignment. I'm going to hand it over to Karen shortly. These are the suggested subcommittees as they were outlined in the bylaws. These could change, and then we would have to allocate and change the subcommittees assigned. But we. Karen, if you, I'll switch over to you.
Okay.
Sorry.
No, I think I'm giving you a break because you just finished. I know how it's like to finish all those slides in a row. So I think when you look at this suggested subcommittee assignment, what we did was we went through your bios and your CVs and tried to find the areas of your expertise or the areas that you, during the interview process and such, areas that you stated you were interested in. This is sort of what I like to say permission to hate document, meaning we just tried to get things together so we had something to start with. But if you would like to be on a different committee or you are not happy with the way you were assigned or you'd like to do something different, or if you'd like to suggest different committees, we're going to open this up to have that conversation, right? But we just wanted something to start with to start the conversation. So I am going to open it up now for you guys to jump in and discuss.
Should we just talk if we're
Yes.
up for talking? Hi.
Yes.
So I did have some recommendations for amending the subcommittee format. I thought it might be helpful to structure, and partly this is, I'm motivated by the urgency that we have, of course, to come up with the recommendations in less than 6 months. So I thought and considering the subcommittees will begin meeting and doing work after this board meeting. So this is kind of our shot, I think, to get us set off on the right trajectory. I thought it might be helpful to structure the subcommittees around the things that the board is required to make recommendations on, which of course includes the things that DORA is required to issue regulations on. So I developed a draft that takes all those different provisions of the NMHA, allocates them, buckets them as best as I thought was feasible, although it's certainly up to kind of debate among I think it's 6 different domains. So I want to share that document with the board. Is the appropriate way to do that to put it in the chat?
Yes.
Okay.
Ashley, how would you like that to happen?
I think it's worthwhile to have the conversation here and perhaps share. There's a way to share that document, and then
I think Billy, if you will email it to Catherine Duran, then we can have her put it up on the screen so the public can see it as well.
Okay. Just a second.
Or to you.
Yeah.
Oh, okay. Actually, Billy, if you could email it to Sam, we can get him to put it up.
Okay.
Oh.
I'm just kind of navigating this Word email interface here. Sorry.
Stop sharing. Give it to you. And you're downloading it too, right?
Yeah.
Sorry, we're just figuring out how to share it. so we can make sure, I want to make sure everyone sees it, not just all of the board members, but also the members of the public. So just give us 1 second.
Okay, it's heading off to Sam, I'll
Okay.
let you know.
It actually might be a good time. Do we want to just take like a short 10-minute break? Bio break? And then we can come back. We've been at it for a while. So why don't we just have everybody just shut off your camera and make sure you shut off your microphone, and we'll meet back here at 2:40.